Mark O'Meara represents George Zimmerman. He joins me now exclusively. Mark, good to have you back.
Good evening. Great to see you again.
On the face of it, it's being billed as a pretty bad day for you guys on the defence because almost all the stuff that you wanted to be admissible was ruled out. How do you see it?
Well, I didn't see it that way at all. I'm not just trying to look for a silver lining. My intent was that we try this case on the 5 or 6 minutes it happened way back then on February 26th. And I recall saying that to you, Piers, the first time we got together and talked. The intent was that we want to make sure that the information is available to us, we have, and it doesn't need to be said in opening and shouldn't be said in opening, and only will be used if the state presents their case in such a way that we have to respond with some of that evidence. My hope is none of it gets anywhere near a courtroom, but that's only if the state plays by the rules that they're supposed to play by.
Tell me this, I mean, what is the relevance, really, of whether Trayvon Martin had been in an aggressive mood, whether he took pot, whether he was photographed with guns on his Facebook page or whatever? What is the material relevance, really, to what happened, as you say, in the crucial 6-7 minutes?
Well, if in fact his history is relevant, if the state makes it such that it's relevant, we have to look at the fact that he was on pot, and we know that he had at least enough in his system that the state experts suggested there could have been impairment. There are studies out there that say, in young males particularly, pot use or withdrawal from pot use can lead to aggression. So these things could become relevant. As far as him having a hand on a gun, that could become relevant because, as we know, part of the evidence is that he may have seen the gun and even gone for it. So that could become relevant according to how the state presents the case. Again, we're going to be reactive, not proactive. You might recall from the hearing today, I was the first one to say, Judge, let us limit ourselves in opening. Because as long as the state is limited and the defense is limited at opening, then the judge gets to decide what's relevant and when it should come in. And that's got to be a dynamic decision that's made only as the evidence unfolds.
I mean, one of the crucial things, I guess, for you guys is going to be the jury selection. Because I'd imagine this is going to be a hugely emotive case. We know that already. And those members of this jury are going to have huge burden on them, I think, right across America to make the right decision. How are you viewing that process?
Well, that's why I asked for an anonymous jury. I'm very concerned that the jury is, in fact, going to be impacted by the social pressures that have been placed on the case. I'm very concerned about that. Ben Crump, who I know is going to be on in a minute, has suggested that this is a civil rights case of the century. I just have to disagree with him fully. This is a self-defense case. It happened in a few minutes with the intersection of two people. My fear is this. If, in fact, a jury looks at this case and says George Zimmerman acted appropriately in self-defense, if they make that decision, is that truly a loss for civil rights? And if so, someone needs to explain to me how.
In terms of George Zimmerman himself, the latest pictures of him in court, he looked to have put on a huge amount of weight. He looked under great stress. Describe to me his physical and mental condition right now.
He's facing a prosecution where they're trying to put him in prison for life for an event that he believes he acted reasonably and in the only way that he could. And he is in hiding because he can't go out in public. He's gained an enormous amount of weight, over 120, 25 pounds, I think, because he's sitting in a house, stressed, trying to deal with the moniker that's been put on him that he's the most hated man in America for taking the life of somebody when he really feels that he needs to. Nobody takes the life of another lightly, and neither does George. And it's obviously showing in the stress and the way he handles it with an enormous amount of weight gain.
Do you think, Mark O'Meara, that we're ever going to really know what happened? And if we don't know the answer to that question, is it likely to be a tinderbox, whatever verdict comes in?
There was somebody, I think it was on your program, Piers, who said a long time ago that no matter how this case ends up, it's not going to end well for America. He was a defense attorney out of New York. And I said to you off air that I am very concerned that that's exactly what's going to happen. I think that no one who doesn't want to believe in the jury system and the criminal justice system will be happy with the results one way or the other. I think the evidence is going to be such that we will know most of what happened that night because we have the forensic evidence. I won't go over it all, but we have a lot of forensic evidence, and people seem to really want to find out some magical formula to suggest that it just wasn't Trayvon Martin's fault, because they don't want to suggest that a 7-year-old could have caused his own death. But those who want that as a result will never accept an acquittal, and those who believe that George acted in absolute self-defense will never accept a conviction. My fear is that the very thing that Ben Crump says he wants, which is this is a civil rights matter that we should talk about, if we're not careful, we're just going to go to opposite ends of the country and never talk about an event that we need to talk about.
Mark O'Meara, thank you for joining me.
Good to be here.
I want to turn to the other side of the story. It is Benjamin Crump, an attorney for Trayvon Martin's family. Benjamin, welcome back to the show. You heard there what Mark O'Meara had to say. He name-checked you several times. What is your reaction to George Zimmerman's attorney's comments?
Well, first of all, I'll say Attorney O'Meara is not being intellectually honest if he doesn't denote the racial undertones in this case. This is a civil rights / equal justice case, Piers. It is the whole world watching to see if everybody in America can get equal justice. Over 2 million people signed a petition that said George Zimmerman should be arrested for killing an unarmed teenager. There were protests and rallies all over the country, in fact, all over the world, that said you cannot send this irresponsible message that you can shoot an unarmed teenager and not even be arrested, go home and sleep in your bed that night. And so there's a big element of civil rights in this matter. The police didn't even do a drug and alcohol analysis on a self-confessed killer of an unarmed kid. They didn't even do a background check. They took his word as the gospel. They didn't knock on doors to see if this was somebody's kid. They just assumed what George Zimmerman's stereotypical belief was, that this was a criminal. These a-holes always get away. That's the objective evidence in this case. And so we understand it's a criminal case, but it's far more reaching than that. If this is just about Trayvon Martin and George Zimmerman and we don't have a greater dialogue, then we've all lost the opportunity.
I mean, that's certainly true, but it's also true that it might be dangerous if this simply becomes a civil rights trial, in the sense that it may have had in the end, and we haven't seen all the evidence, nothing to do with racial profiling by George Zimmerman, and much more to do with what many believe to be the crazy stand your ground law in Florida. And that is why the authorities, from the police onwards, acted in the way that they did, not because Trayvon Martin was a young black man.
Well, Piers, we believe that if the shoe was on the other foot, Trayvon Martin could have said he was standing his ground, could have said self-defense. He could have said anything he wanted to say that night. The police would have arrested him. The police would have took him to jail. He would not have went home. And so that's the issue. And I want to say one other thing. Attorney O'Meara talked about his client's state of mind and the fact that he's depressed and gaining weight. Well, imagine Sabrina Fulton and Tracy Martin, what they have to endure. Their child is dead. He's never coming back. Sabrina has lost a tremendous amount of weight. I would submit to you that she's undergoing more emotional loss than George Zimmerman is.
That I'm certain is true. That's an irrefutable fact, and will, of course, be at the centre of this trial. Let me ask you the question I asked Mark O'Meara, which is about the jury selection process. It seems to me this is going to be pretty crucial to how this trial plays out. What is your view of how this process should play out?
Well, I don't think Attorney O'Meara and the defense team helped the matter by releasing all those photographs and these text messages that they knew were going to be inadmissible. I think it was a strategy to pollute and persuade this jury pool, and that's not right. I think that we need this trial to be very transparent, to be very fair, so everybody can accept the verdict when it's returned. Trayvon's parents have asked from the very beginning that all they wanted to do was make the killer of their unarmed son come to court and face the evidence against them so they can have their constitutional rights. And that's all they've asked for. And when they waived their stand your ground pre-trial immunity hearing, then the protesters were validated and saying that it should go to court. It should be a matter that comes before a jury of George Zimmerman, Piers. And finally, what you said, asked Piers, we believe in the jury system. We believe that if the jury is honest with the judge and say they can be fair and base their verdict on the evidence that's presented in the court, on her instructions, then they will arrive at the right verdict, and everyone has to accept the rule of law.
Benjamin, just wait there 1 second, because Mark O'Meara's been listening to this and actually does want to say something by way of response. Mark, you're still with me, and you want something to say.
Well, very briefly, a year ago I had a conversation with Ben Crump, and I told him that he needed to be very careful putting Trayvon Martin on such a high pedestal, because he's really just a 17-year-old that comes to the table with whatever he came with. And now, a year later, they suggested what we did to put out the evidence that the family and Mr. Crump was aware of for the whole past year. They knew who their son is. They know who he was. They knew about the suspensions. They knew about the charges. They knew about all that. To suggest now that it's our fault by following the discovery rules that says if I don't do my job as a criminal defense attorney and present that information to the state, that I can never use it, talk about being intellectually dishonest. That's just, if Mr. Crump has tried a defense case, he knows
Mark,
what you have to do.
I have to leave it there, but last word to you, Benjamin. Quick response, please.
Absolutely. One of the things, when we are lawyers, we know the rules of evidence. We know what's admissible and not going to be allowed in. It was not admissible. It was irrelevant. It was not Brady rule evidence. It did nothing to support George Zimmerman's guilt or innocence. It was done solely to try to persuade the jury and influence them.
OK, well, it's clearly going to be a very contentious trial. Thank you both, gentlemen, Mark O'Meara and Benjamin Crump, for joining me. I appreciate it.
Thank you, Piers.